Welcome back on the AM show, and now we're going to talk about the election petition, which has, well, taken all our attention in recent weeks. We're getting into that. Last Friday, the court adjourning, the sitting to this morning at around 9:30, and we're going to be witnessing, Robert Joseph Metonunu, who happens to be the third witness for the petition, actually getting into the box today to deliver what is his witness. It's going to be via video, it's going to be virtual, and after that, should time suffice, we shall also have Jean Mensa, the EC chair, the first respondent. But to help us get into the matters this morning, we're going to be interacting with Samson Lade Anyenini, lawyer, host of Newsfile right here on this network. And if I might add, the reigning journalist of the year. We also have Joseph Akable, who is our court correspondent. They're going to break down the matters for us as we dig into it. So on that note, I'd like to say a very good morning to you, gentlemen. Samson and Joseph, good morning to you.
Good morning.
Good morning, Ben.
Great to have you. Now, I'll start with you, Samson. It's been quite a course we've run over the last few weeks, and on Friday, culminating in, some of those, requests that were made, some elements of the witness statement being struck out, about 5 of them. Let's take from your end a quick recap of Friday's session in court. What did you see and what did you make of the happenings, Samson?
Right, so what happened last Friday could have been avoided, but it happened. The reason I say it could have been avoided is that CI 99's provision for pre-trial session, which it has dedicated 5 days for. All the parties were very sincere and forward about the process, and it got to that point, and the court, not feeling that time had run out on it, the 42-day timeline had run out on it, and therefore it needed to speed up the process in some way. Otherwise, the parties, particularly the petitioner, would hold the process hostage. It could have dedicated those 5 days to case management. We call it CMC, Case Management Conference. At the Case Management Conference, normally, all the witness statements ought to have been ready. Any witness, any party intends to call, the party ought to have had that particular witness's statement in the court on the record, and then the judges together with the lawyers would have looked at the various statements and then would have taken decisions, including what in the witness statement ought not be permitted. What in the witness statement was something that had not been pleaded and was being smuggled, had not been pleaded in the pleadings and was being smuggled into the witness statement. Because the ground rule is that you don't bring in fresh matters. All you have to deal with in your witness statement must originate from the pleadings themselves. And in this case, the petitioner's petition and the accompanying affidavit. Now, if there had been a case management conference, CMC, and I have discovered that there's also the other argument that the court, in this case, reserves the right not to use the standard CMC that we are used to in the courtroom, because that's actually a new process. And to have gone ahead in the manner things have been done. But if that had been done, once again, I emphasize that what would have happened is that some of the delays that have happened with respect to lawyers for the respondents opposing portions of the witness statement of the petitioner's witnesses would have been dealt with at the pre-trial or case management level. All those matters would have been trashed out. And so when it came to putting a person in the box, like it happened on Friday, Roger would have been put in the box and then immediately would have heard his testimony and would not have had to spend that day going over the witness statement. So, but we have lost that. So no point crying over spilt milk, if you like.
Right.
We expect that today the process will not be delayed any further, but because it happened, and because there has not been a case management conference done, this is the next thing you must expect, that the witness statements of the respondents' witnesses, Chachu Chikata, is also likely, when it gets to his turn to cross-examine those witnesses, he is likely to also begin by saying, I have seen portions of the witness statement of Jean Mensa or McMenu which ought to be struck out or expunged. And that could take us yet another, journey of a debate in trying to sort out what must constitute the witness statement that must be used for those two witnesses going forward.
Right. Samson, so quite a number of issues that are being brought here, the management of the situation, what processes should have been taken care of, under normal circumstances in a court of law. But I want to find out from you, this failure by the petitioner's, legal team to actually include in their pleadings what they added in the witness statement of Roger Meto Nunu, was that a lapse, would you call it, on the part of the petitioner's lawyers?
We have to, at this moment, defer to the superior wisdom and law. Like, we know as lawyers that the law is in the bosom of the judge. And so once they have ruled on it and held on the basis of Section 166 of the Evidence Act, that, forgive me, but my trend, I was actually going into the discoveries that were denied last week. Sorry, that's not what we are talking about now. Once they have ruled on the witness statement, the application for as many as 23 of the paragraphs to be expunged succeeded only in part. And like you mentioned, it succeeded only in getting 5 of the paragraphs removed. To the extent that those paragraphs, as the court said, will occasion prejudice, among other things. That is where we leave it. But you see, whether it was a lapse or not is a question that you may look at what Chachu had to say, because he said that things had been done in the responses by the petitioners. And the only way he felt they could respond to them was to also use their witness statement as a manner of responding. So there and there, he gives you an indication that there is no issue of lapse. But it must be said that the respondents also made a very valid point that most likely the petitioners would not have called Rojo Metalunu as a third witness if what they had expected would have happened with the two witnesses, more particularly Dr. Kwesa White. That it's because something's happened when Dr. Kwesa White gave his testimony, and that didn't help, and was the reason they needed to call Rojo Metalunu, who, according to Kwesa White, is the one who had the said instruction or was asked by the Electoral Commission chairperson to leave the place, so to speak, or to make contact with the petitioner to resolve certain matters, which we have not been told what exactly those matters were.
Right.
So yeah, that's what I'll have to say about that.
Samson, so I'll come back to you for us to take a brief look at some of those paragraphs, 4, 5, 6, 7, and 18, and what exactly the implications are of, expunging them or taking them out. But let me cross over now to Joseph Akable, our court correspondent. Joseph, what exactly do we know to be the statement, the witness statement of Rojo Metalunu?
And so Mr. Metalunu, as you know, was one of the two representatives of John Dramani Mahama, the Electoral Commission's National Coalition Center, popularly known as the Strong Room. And so his testimony focuses mainly on the events that took place in the Strong Room. And he makes the point that in the course of the coalition process that they were observing, they realized that there were instances of different results that were coming in, and challenges with the computation process that they observed, that they tried to draw the attention of the Electoral Commission chairperson, but she did not heed to those concerns in allowing those corrections to be made. He also makes reference to the Eastern region, where he says initially they were brought pink sheets, and later on another one was brought that when they compare the figures on, they are different figures. And so until he sees the original from that level, he's unable to tell which one is the authentic one. Then he makes the claim that you recall Dr. Kwesa White had talked about with regards to being sent or being instructed. Dr. Kwesa White actually had stated in his witness statement that he was asked, but in other portions in the course of testimony, he makes the point that they was instructed to go. And so that is also another issue that we understand he will be speaking to, in the sense that you recall when Dr. Kwesa White was asked directly about if during the 2 days of being at the Strong Room, if he interacted directly with the AC chairperson, he said no, and that the information about being instructed to leave came from the EC chairperson through Mr. Rojo Metalunu. And so Mr. Metalunu is expected to testify to that effect as well. It's already in the documents that he's filed, and so he'll be cross-examined on those matters too. And we understand that the lawyers will be asking questions about whether with his wealth of experience, indicating that from 1992 he's been quite a regular feature at the Electoral Commission Strong Room, how he was able to be instructed by someone that the party didn't even trust when she was appointed as EC chairperson. There was another claim that he makes in his testimony about being misled, i.e. he was told by the EC officials that once his agents at the regional level have signed the coalition sheet, the only option he has is to go to court. And so that is why he signed the document. We understand that he will also be probed further on that particular issue, and questions to be raised about the fact that for someone with his wealth of experience, how exactly does he allow himself to receive such a directive and proceed to say that he was misled by the EC officials?
Now, with this witness statement, this third witness for the petitioner, and with the portions that have been expunged, the 5 of them, how does this witness statement in its entirety, what is going to be, looked at in court today in its entirety, how does it impact the case of the NDC? Does it add to the NDC's case in any way, from what you gather?
As far as the NDC and Mr. Mahama's side is concerned, for that matter, they have made a point that they still think they have a rock-solid case. It's worth noting that what the court did in taking out some of the issues, those were mainly issues that have not come up in court entirely. And so there was a very serious allegation about the fact that in the course of the coalition at the Strong Room, the EC's fax system, which was supposed to use to transmit the results from the regional level to the EC's headquarters, were not working. And so the claim was that Dr. Siribo Kweku, a director of electoral service at the Electoral Commission, was walking into the strong room with results that he did not know where he obtained them from and did not explain where he obtained those results from, and submitting those results to the officers who were undertaking the coalition then. So that was quite a serious allegation that has been taken out of this particular narrative. There's also another one related to Northern region, where the claim was that, like the Eastern region, 2 seats were brought for the Northern region, but the point he was making was that the figures were different, and at that level he couldn't confirm which one was the authentic one until he sees the original is unable to tell. So that one has also been taken out. Effectively, what remains before the court are largely the issues that have come up in the course of the cross-examination, or issues that he himself is knowledgeable of, that he has been able to deal with or speak to in terms of the witness statements. And so for the petitioners, they say that their case is still rock solid, and they have corroborative evidence now to the effect that indeed Jean Mensa had asked or instructed, depending on who is testifying, Mr. Roger Metununu and Dr. Kwesa White to leave the EC's headquarters. But as far as the respondents are concerned, they make reference to the issues that the court set for determination to argue that Roger Metununu's testimony, whether taken in its form prior to the striking out of the 5 portions or taken in its current form, does not really address the concerns that the court have set for determination. And so those are matters that the two sides disagree on.
Very quickly, back to you, Samson, and I'm just going to take a quick look at some of those paragraphs that were struck out, 4, 5, 6, 7, and 18. 4 would focus on the EC failing to carry out her duties as per the Constitution in the declaration of a winner. 5 would have to do with the request or testimony concerning the airing of a video documentary shot by a person in the strong room. There would be 6 with regard to fax machines not working and being slow. 7, the allegation of, that was just mentioned by, Joseph Akable with regard to Dr. Siribo Kweku bringing to the strong room these sheets from which they do not know where they emanated when it comes to the regional coalition sheets. And finally, the regional result sheets for the northern region, there being 2 of them. These are all matters, when you look at those paragraphs that have been taken out, that actually border on critical issues being deliberated upon in court. How much of an impact do you feel it will make on the petitioner's case? Will it water down the strength of the petitioner's case in any way, Samson?
It's difficult to say because, look, every lawyer has a strategy to how they conduct their case. And so an attempt to second guess what the petitioner will do in the circumstances will not be appropriate. But I can say this, that cross-examination gives you latitude, and we say that all the time as lawyers because that's what the rules are. Cross-examination gives you a wide opportunity and room to try as much as possible to traverse or deal with almost everything. Therefore, as you heard, that the interrogatories that were denied, the petitioner, they could, take advantage of cross-examination to deal with the interrogatories and get the same results. It's possible that what they were seeking to achieve with these paragraphs that have been expunged, they potentially could use the forum of cross-examination to traverse them.
Right. Right. So there are other mechanisms, basically, that the petitioner can employ with his legal team to arrive at the same ends, basically. That's what you're saying.
Yes, so every lawyer has a strategy to a case, and every lawyer has the end game in mind. Well, if you don't have the end game in mind, you have no business being in the courtroom. So you have the end game in mind, and then everything you do is to assist you to get to that end. So if at one point you are shut down, you must...
Well, it appears we have a bit of a connection lapse there when it comes to... Okay,
yeah.
Samson, you're back on. Good.
Yeah. Yes. So once you are shut down in one area, you necessarily must find an innovative way of achieving that important goal if it is one thing that must be achieved, otherwise your case falls. And we almost always will find a way of another way of achieving that goal because it's part of the building blocks to the end game.
Okay. Let me quickly, before I come through and take your final comments, your expectations for today. Joseph, what should we expect from today's cross-examination as we have, Metal Nunu back in the box? And it's going to be virtual again. It's going to be by video. Are we going to have someone from the court today as well, with Metal Nunu monitoring him?
Yes, we understand that is supposed to be done per the request that was made by Mr. Kutampa on Friday that was granted by the court. You recall that Mr. Chikata supported that particular request, saying that is what ideally should happen. And so we understand that it's by video again, and this judicial officer will be available at his end, Mr. Rojo Metinunu's end, to remind him of his testimony and also to ensure that no one comes in the course of the cross-examination to assist him in the responses that he provides. And so that is what we are expecting to happen. We understand that it may not necessarily take a long while like we saw in the previous ones. That is in the case of Johnson Asiedu Nketia. We understand it may be slightly shorter this time around. And so that is what we are expecting here. And the conversation, like I indicated, will mainly center around this being misled to sign sheets at the EC's National Coalition Center, as well as the claim about being asked by Jean Mensa to go over and consult with the party's presidential candidates. And if that is done on time, then we could see Jean Mensa also go into the witness box. There's another issue that I don't know what Samson will make of, but it has to do with the number of days since the case was filed. And per my own count, we should be was filed on the 30th. And so if we add 31st and 31 plus the 8 days, we are around the 40th day now. I don't know whether he holds that view that some lawyers have put across, that it's a single day count such that we have 2 more days to go.
Well, very quickly, Samson, if you'd react to that.
Right. I have held the view that counting each day from the date of service of the petition may not be what the law and the lawmaker anticipated. Otherwise, I do not see why the lawmaker in CI 99, whilst providing the time schedule, put the 42nd day and expected it to end or to happen in March. By the lawmaker, you see in the schedule 2, you see clearly in that schedule, the second schedule, that whatever schedule it is, I'm not recalling it exactly quickly. That schedule says the day starts counting from January, and then the 42nd day when judgment will be delivered will happen in March. So I prefer to keep to that rather than a computation that ends before March.
So per what you are saying, what day are we on today in terms of the court process? Per your understanding of what you are relating to us.
I have not counted.
Finally, Samson, what would be your expectations ahead of today, very briefly?
Well, I expect that once the issues with the witness statements are out of the way, straight away the witness will begin to take questions from first and second respondent lawyers. As has been demonstrated over time, it is obvious that first respondent lawyers may spend a bit of time with him, between 30 minutes to a little above that. And then second respondents lawyers may not waste time, so to speak, may not waste time on him. May I ask just a couple of questions? And the strategy is very clear that, as they did for Professor White, they decided to be very brief and on questions that bordered more on law in a way that didn't give the witness room to try to correct any mistakes or anything that the witness had done in the cross-examination with Justin Amenuvo, and to try not to allow the witness to open other issues,
right?
To try to, as it were, hold their case. But with regards to the guy you asked, the judicial officer who will be with the witness, I expect that it is likely that the one who was there on Friday will be changed to avoid the possibility of familiarity after he had the encounter with Rojo and his team on the first day,
right?
Which may give room for the possibility of some compromise of sorts. Okay. So you may see a new person being sent there rather than the one who went there the last time. The police officer who accompanied may remain the same or could also be changed.
Well, some interesting tidbits we've brought to you as far as the election petition is concerned. Let me say a very big thank you to Samson Lade Anyenene, lawyer and, of course, host of Newsfile right here on this network, as well as our court correspondent, Joseph Akable. That case, adjourned from Friday, continuing today in court at 9:30. Do stay with us. We'll bring you more of that. But now we're going to be talking about how you can own your home the right way, stress-free, and at the best cost. That is up next on The AM Show. Do stay.